Mr. Alan Baker. I did speak with him downstairs this morning when the case was going on and advised Mr. Hawley that he was requesting a continuance yesterday. And I believe Mr. Baker had a DUI case downstairs during the same time. He asked me to request a continuance because he couldn't be here. He was just I've reached out to 4 other different lawyers' offices, including legal aid, in the last 2 weeks to cover all of these motions that have been served on me. Amy Sawyer with the domestic advocate, legal aid, Ms. Robert, who was here earlier, Ms. Duke, and Mr. Baker yesterday. And Mr. Baker took the case yesterday, and I had my friends drop off the documentation.
Well, Mr. Baker has advised our clerk that he has not been retained to represent you, and therefore the fact that you've not hired an attorney according to what you're telling me and what Mr. Baker tells me. This was here today because on the March 23rd of this year, which is 1 week ago, a motion for a restraining order was filed, and based upon the allegations set forth in that restraint motion, the court issued a temporary restraining order that can only remain in effect for a set period of time, and I set it for a hearing for today on the 30th day of March. You have the right to have an attorney because, number one, it involves the possession or use of the marital residence. Number two, it involves the question of whether or not the restraining order should or should not be continued in force. Pardon me. And as a result of that, I am trying to determine whether or not you're asking for a continuance for you to hire a lawyer. Is that what I'm understanding?
Yes, Your Honor. I spoke with Mr. Baker downstairs when we recessed. I went to his office. When I spoke to him yesterday afternoon, like I said, his documentation was dropped off, and I was going over there this afternoon to officially retain him.
Mr. Hawley, she's asking for time to hire an attorney, and she's essentially, this has been less than a week since this, or exactly 1 week since this order was entered, and I think she was served on the 23rd day of March, so she's only had 1 week. Do you have any opposition to rescheduling this with the order remaining in full force and effect?
Address court.
You may.
Well, we're here today for the possession.
I know the court. Mr. Shelton, Mr. Claiborne.
Mr. Claiborne, yes.
Claiborne, come up, sit at the table if you will.
Well, Judge, here's the biggest issue of the situation. There is also an order of protection. Let you know what we're here for. There's an order of protection that she filed downstairs in General Sessions. It got served, it got filed, and it got signed as the ex parte order of protection. We were in court Tuesday, and Judge Monsu moved the order of protection hearing to Chancery Court. It was set for the 4th of April, and I had a motion to continue, and I was busy that day. Or to move it to Chancery Court, and he moved it to Chancery Court. And I don't know if you have the file yet. There's still a process of all that. So
I've just been handed a document that apparently was filed yesterday afternoon, a copy of the order that transferred the order of protection to the court.
Yes, and we heard that on Tuesday afternoon. But that's the other, and I bring that up because that's the other time-sensitive, hearing that the court has to have in addition to that restraining order. I know the court's apt to give her a continuance for an attorney. It's a general rule. The problem is with Mr. Claiborne, this is a 5-month marriage. They've lived at that home since December only. And this home he has lived in for years. It was in his and his deceased wife's name. I've got the deed. The court wants to see it. This is solely his property. He has a business that he operates out of more or less the basement for warehousing purposes of repairing forklifts. I've learned about forklifts in this case. Apparently, from COVID and some of the manufacturing problems that we've had, there's like cars, no new forklifts on the warehouse floor to sell, and everybody wants their forklift repaired. He does quite the business. This is a situation where with this house also, I have coming to court to testify, she's here today, is a neighbor that's going to testify there are parties going on. I have photographs, I have video. I have a lot of unsultry things apparently going on over at that house on a more or less at least every other afternoon basis, of a lot of cars in the driveway, a lot of cars coming and going at all hours of the night, people jumping in and out of the hot tub. It's kind of ridiculous the way the house is being treated, and that will be the evidence before the court. What I'm asking for, and I know the courts have to continue it, but what we're asking for is, and it is his property only, to have some sort of access to this house on a daily basis during the day. He'll go somewhere and spend the night till we can come back to court, but we're asking for some sort of like 7 a.m. to 4 or 5 p.m. access to his own property at this point, so that he can go down to the basement, pick out the air filters, the fuel filters, all of the oil, all of the things that he needs for his day and the parts that are over there, and have access to this house on pretty much a random daily basis. So he can come in there and do that. And she has every available means to go somewhere during the day, and she can come back and stay at night. We're also asking that there be no one over at this house other than the two parties. You know, there's no reason for anybody else to be at that house other than the two parties. There's nobody else that lives or resides anywhere in that house or with them at this time. So if there's some sort of restriction here that says that, you know, those two will live there, or excuse me, that she will stay there at night, you know, without anybody else being there, and he's allowed to kind of come and go during the day, we can set up some hopefully time parameters here where, you know, this will work out until we can come back to court. With the order of protection and the restraining order, I think we have to be back probably before that second week in April, if I'm looking at my toes and fingers
Are you
correctly.
available on April the 4th? That's Tuesday.
I've got a full all-day juvenile court custody in Hickman County on that day. But I think about every other day I'm around. I can look at my calendar. I think in all fairness, to have some sort of parameters around this house in the meantime, and that there be no...
Well, the problem is that we're dealing with both your motions in a divorce case where she has requested the opportunity to hire an attorney, and the order and the restraining order that's just been filed on her and served on her 1 week ago. In fairness to her, the need for an attorney applies to all of those things.
I understand.
She has a right to an attorney, and because it was not, it has been a very short period of time, my inclination would be to grant her a request for an attorney, for a continuance to grant her that opportunity to hire an attorney. The question then becomes, of course, obviously, once I continue this hearing, there's been an ex parte restraining order that's been entered, and it will continue until there is a hearing. The order of protection has just been transferred up. It's a temporary order of protection. And therefore, it's going to have some sort of a hearing on that part, if nothing else, in the near future.
And there is also, Judge, a domestic that we were over in White Bluff on Tuesday for about 3 hours. I can tell you this, too, for the court's edification. They agreed and signed an order. May I approach?
Right?
That the domestic bond conditions would be modified to follow the orders of Chancery Court, and that's signed by Judge Smithson. So I think I've got everything available to the court now where the order of protection is transferred up, the bond conditions are in front of the court, so the court can make these type of decisions regarding the marital residence on a temporary basis, whether it's today or later, anything like that. You're in control of the whole thing at this point, I guess is what I'm telling the court.
Not necessarily me, one of the judges on this level. Do you have a judge here anytime in the near future?
We have one in April, and Valerie said that all her docket was full for April, but you'll have to get with her to get the one of
This
those.
is who?
Judge Wallace.
Well, these, which I can, but the order of protection has a time frame that, of course, Ms. Childress has signed. My restraining order has a time frame that, we've worked on, so we've got some, out of there's just some time limits on these things.
They have April 25th, 26th, and 27th, so.
At that point, I wouldn't mind continuing it out and transferring my time frame, but I would need to have something with this house sold because it's costing him a lot of money with this forklift thing. You know,
So many days, I can't give you a day that doesn't exist. That's my problem.
there's an out-of-county experience that we could have here. I'll be glad, I mean, I'll do
Do what
anything.
now?
There's an out-of-county experience that we can,
Well,
I'll
she
do
would-
anything.
She would have to agree to it to be out of county.
It's here, fine.
Holly, let her have the podium,
Yes.
please.
Your Honor, I would like to state that, yes, we did have court on the domestic. I was with the DA as well as Detective Lovell that day. And if I recall, I was on the stand until after 1 o'clock, and then afterwards I had to speak with investigators as well as Ms. Brooke Allen. So that is what was tying me up on Tuesday. In regards to having access to the house, even Mr. Hawley himself mentioned it. There's people taking pictures of my house. My every move is being documented. There's also a police officer with the city of White Bluff that was involved that was terminated. And I'm requesting that absolutely not, he not have any access to the property at this time. I do have individuals staying at the house. One is Mr. Colin Dever behind me. And there's been no parties. And I would be a little alarmed as to how everyone knows my every move. Again. And in regards to his forklift business, he does his forklift repair business out of his van, which he has in his custody. And I reached out to Mr. Hawley's office. I've already boxed up all the oil filters, air filters, everything that I know that he uses on a daily basis, because even though we were only married since October 3rd, I would like to point out that I've been involved with him for almost 2 years or a year and a half. So I'm fully aware of what he needs on a daily basis as I assisted him with his business and all of that. If that's what this comes down to, is he needs to access those oil filters and oil. If the city of White Bluff is not, it's my understanding they cannot be involved at this time. Detective Lovell has been assigned to the case representing the county through Mr. Crouch. I have no problem setting up a civil standby and allowing him to pick up those items that are boxed up that is his work equipment. However, I do request, due to the confrontation that's always taken place at the house with law enforcement there, I do request additional officers be there, and I request that I not be there, and I will leave the items in a specific place.
Are you?
I'll address the court.
Yes.
I mean, again, when we get ready to do this, the evidence will show there's several pictures of parties going on, and this does not look like Mr. Devers jumping in and out of the hot tub and doing these sorts of things. There's a lot going on. We just got some time frames to hit. We just need a date as quick as we can possibly get.
Best I can do is tell you that I can offer you the 4th of April, which is the only day I have available. The rest of my month of April is all committed to criminal matters in Humphreys County, Tennessee. First-degree murder case set starting on the 11th, I believe. Is that right, Ms. McKinney? And every other day I've obligated myself. I don't have any other days to give you. Especially so if it's going to take several hours to litigate, and obviously this is. So they have the 25th, 26th, and 27th, is that right? For Judge Wallace. My best advice would be I'm going to have to continue it to allow her to have an opportunity. The only thing that was before me was the motion for possession of the marital residence and restraining order, and those will both be continued until a hearing that can be set before Judge Wallace on one of those 3 days. So you just need to get with Judge Wallace and find out which day is the best day and set it on that day. And that gives Ms. Childress the opportunity to hire an attorney and opportunity to prepare for a hearing.
Judge, in the meantime, though, is there any relief we can have on the house as far as any kind of access or any kind of restrictions on people going over there where he can just have some access during the day to get his stuff.
Well, the access that I'm going to have a hearing if that's the case, because she opposes that, and that means it's got to be heard. So you're going to have her opportunity to hire an attorney. Obviously, if she's being unreasonable about that, then that's something a judge will take into consideration. If she is not allowing access for no other reason, but there's an order of protection down in this case, so we have to be a little bit careful. So, Mr. Holly, all I can tell you is that if I grant her a motion to continue it, then everything's going to have to be continued. I can't do it piecemeal. And I think that unfortunately, she's going to have to understand that if she denies access to this property for unreasonable, reasons, then you can talk to her about whether or not she'd be willing to agree to some sort of method whereby he can gain access, but she's just stated she's not going to agree to it. So I think under the circumstances, the best I can tell you is that I have to give her an opportunity to retain counsel. I don't have another date to give you other than Tuesday the 4th. You change your other case and you want to have it heard on the 4th, and I'll entertain it on the 4th. Beyond that, I can't help you.
Yes.
And I can tell you that you'll have to go to Judge Wallace on the 25th or 26th or 27th.
What do we do then with the order of protection and the restraining order?
Order protections are supposed to be heard or they expire. The restraining order expires after, it remains in full force effect for 15 days from the date of issuance. So it will stay in effect until that hearing on the 4th unless you have to continue it beyond that day.
As does the order of protection, it expires in 15 days, I think, unless it's heard, correct?
I can extend the the restraining order that I have until the next hearing. That's the one I issued. I have nothing to do with the order of protection thus far.
I mean, just for clarity, because I'm going to get asked this 100 times out in the hallway. The order of protection then, as far as this court's concerned, would dissolve if we don't have it timely heard within 15 days, I think it is. And then the restraining
I'm
order.
not making a declaratory judgment about that issue. I'm simply observing that I am not, this just was handed to me a few minutes ago. I'm not even aware that it had been brought or transferred to this court, but apparently the order transferring it was yesterday. So as of this court's, situation, the order of protection is by the statute, whatever it is. And we don't have judges that can sit day in and day out, as you well know. And as a result of that, we only have cases in which we only have judges who can deal with it in some other fashion. Now, I can only tell you that I will give you the 4th to have a hearing, or you're going to have to go to the 25th, 26th, or 27th with Judge Wallace. You'll have to get that cleared with him.
May we set it on the 4th, like in the afternoon? I don't know what the court's docket looks like on that day, but if we could do it at 1 with the thought that if I get my hands tied over in Hickman County, I may have to call or do whatever. I'll try my
I have a
best.
half-day hearing already scheduled that day. So, and that's, you
From
would
the
be
morning?
after, you would be after that, so that would give you an opportunity to go, if that's what you need to do. So, if you want it set for the 4th, I'll give you the 4th.
But the 4th, maybe at 1 o'clock, is that appropriate?
I'll set it for April 4th at 1 o'clock.
And then if I can't make it, it might not be held against me too bad, or you're not going to send the police after me. I think that 4th thing, they settle, so maybe it will settle. But I'll try every way to work it back over here at 1 o'clock. That's appropriate. If not, then maybe we can pick one dates later in April.
I'll reset this for April 4th to allow Ms. Childress the opportunity to hire an attorney. April 4th, that's just Tuesday at 1:30 will be when it will be heard.
And thank you, Judge. I appreciate your time.
All orders remain in full force and effect until that time.
Yes, sir. Thank you.
All right.
We're back for hearing number 2, which is the same motion as hearing number 1.
But what we have here today is the motion for a temporary possession of the marital residence. I decide I wish to make a opening statement.
Judge, if we can, I would like to do a quick announcement on that restraining order, make sure we're all good with it, and then we'll move on from there. I am going to request a rule, please, of course.
Rule has been requested. If there are any witnesses in this case, they must go outside of the courtroom and remain outside of the courtroom until you're called to testify. Do not discuss the testimony of any other party until you have testified yourself. Counsel are under continuing duty to ensure that rule is complied with. Mr. Woodall, what's the other one? Odle? Mr. Odle, Mr. Woodall, you have the case after this, and if we do not get to it today, you can have it heard if you want Thursday. Here in Dixon Chancery, we have the Marcello versus Marcello that you're involved in, so we can have moved this case to Thursday morning as well.
Thursday morning will work with me, all right?
All right. We'll hear it first, your motion first, and then we'll hear the Marcello case thereafter, because this is set before the Marcello. So you're welcome to wait around. I'm just simply telling you that if you need to go, that's what'll happen. So, you know Mr. Holly and Mr. Becker well enough that at 3:30 in the afternoon, if you think they're going to get to it before 5 o'clock, then wait around. Mr. Holly, you can announce your agreement.
The agreement for the restraining order will be as follows. It'll take me a minute. I just came out with it out in the hall, but basically the restraining order is going to be agreed to with both parties participating in the agreement, such that both parties will be restrained from accessing any and all emails, social media, or any other accounts, financial or otherwise, bearing the name of Kimberly Claiborne, C&K Forklift, Christopher Wayne Claiborne, or Amy Childress. If there's anybody else we need to throw in there, I'll be glad to think, we'll talk about it. Basically, the parties at that point. The parties are restrained from having any involvement and or contact with any of the accounts, pretty much the same thing, including but not limited to their LinkedIn accounts, their Facebook, banking, credit cards, or any other accounts dealing with the business of the husband, namely C&K Forklift. And I guess that's other than Mr. Claiborne has to have access to that because that is his business. That would more or less fall under number one, I guess, at that point. However that works itself out. She has so I understand that there's a LinkedIn account, and somehow or another it got to shown up on there as she was the owner. And I think he's got one and maybe she's got one, and that's how it kind of happened. But I'm assuming she would agree to take, if it's not up to him, she's going to agree to take that down where she's the owner.
I don't know that she's the owner. I don't know that she's the controller of that account.
Of the LinkedIn account? I didn't know if she had one. He thought that she
I
had
have
one.
my own for the company, that the one that's got messed up is not mine. I still have mine for the business.
Yeah. Both parties are going to be enjoined from making Amy Childress the owner of the LinkedIn account, and both parties, I guess, would be restrained from not cooperating with each other while we try to resolve that one account that says maybe she is the owner, and you see that attached to the motion. So that's the one thing that we need to be doing. Is that fair enough?
That's fair.
And I understand that, according to Ms. Childress, she doesn't have any information with any of the passwords that were changed to the email address of his late wife, Kim Claiborne, 1973 @gmail.com, or any of the other things that are listed here. But both parties would be court-ordered to give up any passwords. If they've changed any passwords on any accounts of the other, both parties would be ordered to give the passwords to the lawyers, and we'll pass it on to our respective clients. And the other thing is, he's got, and we've contested this, it's going to be very contested, domestic with the bond conditions. There's that order of protection that the court saw that came in. And my client was worried, and I think with good concern, and it would actually be reflective on both parties, that if we try to get back in Kimberly Claiborne's email, which by the way is used for the business she was big with the C&K Forklift with Mr. Claiborne, and That was the name, Chris and Kim Forklift. And the client still used her email quite a bit, so he needs to get back into that thing, and he'll work to get back in or hire somebody to get back in. But when we do this, my understanding is, and I'm somewhat familiar, of course, I'm stuck in the 1980s when it comes to electronics. I did get close to Jelly Roll at the Tides game, so I do know who that is a little before you did. But the Kimberly Claiborne thing, if we try to get back into that account, it may very well, if there is some reflection with that email that we saw, it might ding her phone. She might get some sort of acknowledgement that we're going through some verification to change Kimberly Claiborne back, where Mr. Claiborne can have access to it. But if we have a Google notification or we have any other notifications that ding the phone of the other one, that will not count as a violation of anything, albeit the domestic bond conditions, which this court has, the court in White Bluff City Court agreed that you have full reign to change those, whatever you want to do, and I passed that order up prior. But whatever it is, if somebody gets some sort of notification that we're changing these back, it's not going to violate that or the order of protection. So if I missed anything, let me know, Mr. Mayor, but I think that covers it. And I'll do an order accordingly. And
Let's take a short recess. Let me stretch my leg for a second.
yes, sir.
All rise. This court is in recess.
All right, if you wish to make an opening statement, Mr. Holly, go ahead.
Judge, briefly, just to give you a little roadmap, this is a 5-month marriage. Married in October. They moved into this house in December. They haven't been there long at all. There's a domestic, there's an order of protection, there's everything that could possibly be done has been done, I think. It's been highly contested from Mr. Claiborne, and it will continue to be highly contested that he ever committed a domestic assault, that there ever was a valid order of protection that needed to be done. What you're going to hear from us today is that he's had this house since 2016 with his prior wife. Prior wife passed away of a horrible situation with COVID. He was on one floor of the hospital, she was on the other, and it was horrible. But anyway, she's passed away, and of course the house is and continues to be his sole separate property. The marriage has taken a horrible turn for the worst, and these parties are in a situation where they can't agree to much. The neighbors are going to testify about all the ongoings at the house. I think there's significant waste that this court needs to hear about a little bit in this situation. I think the evidence, when the dust settles, you'll see that the wife does have sufficient funds to get a place and to move on. I really think, we get into these and we know that short-term marriage is only one or two things that apply, but I think the biggest issue in this is possession of the house out of the whole marriage. So we're asking the court to hear that today. He wants his house back. He's been living in hotels. So that's what the court's going to hear. And he runs his business out of his house. And it's instrumental for that aspect. He stores and keeps forklift parts again. And I've learned a lot about how that works. Everybody nowadays, with the way the world turns, they're not making new forklifts like they weren't making new cars. And everybody wants to keep their forklifts running. And he's got quite a business being on call and things like that to keep everything going, and it's totally disrupted all of that. So that's our
Maybe
duty
you wish to
today.
make an opening.
I'd waive, Judge.
You call your first witness.
Call Jerry Johnson. She's out in the hallway. Let me get it. You got it. Let me get it. You got it. State your name, please, for the record.
Jerry Johnson.
Ms. Johnson, where do you live?
I live at 5276 Highway 70 East in White Bluff, Tennessee.
In correlation to Mr. Claiborne's home, where is that?
Right next door.
Okay, so you are familiar with Mr. Claiborne?
Yes,
How long have you lived there?
I moved in February 1st, 2021.
How do you find Mr. Claiborne since that time as your next door neighbor?
Great neighbor, always looking out for each other. When he would leave town, he'd let me know, various cars were going to be there. Keep an eye on the house and vice versa.
Good.
Share the same lawn guy.
I'm sorry?
We share the same lawn guy.
Okay. Now, you're aware that Mr. Claiborne has been removed from the home, correct?
That was brought to my attention on the 6th of March.
Okay. And what is it like living next to Ms. Childress at this point?
Various cars in and out, different cars, probably a new car every other day, but multiple cars there.
And with these multiple cars, they're going in and out. When are they going in and out?
All times of the day and night.
Have you noticed unusual people over at the house?
Yeah, some familiar and some unusual.
How often do you see people over at the house?
I would say there's people over there at least on a daily basis.
You seen any of the same people?
Yes, some of the same people.
May I approach?
Right.
Show you a picture and ask you if you recognize this picture. We got a few pictures to get through.
Yes,
You
I do.
recognize that? What is that a picture of?
A few people in the backyard in the hot tub.
And you remember when that picture was taken?
Not the date exactly, no.
Was it taken during the time that Miss Childress was over there?
Yes.
May I approach you, Judge?
You may.
Let me show you another picture and ask you to set that down. Ask you if you recognize that picture.
Yes, I do.
And again, was that picture taken during the time that Miss Childress was over there?
Yes.
So what is that a picture of? Can you describe that to the court?
Two ladies getting in the hot tub.
Okay.
Judge, I'm gonna object to the relevance of this unless this is going somewhere.
Judge?
Well, I've been hearing cases involving a lot of irrelevant things today, but I'm going to allow it, overrule the objection. Are you wishing to make these an exhibit collectively? or-
Collectively in a minute, Judge, yes, and we don't have to do it. Time I could approach.
Right.
Show you another picture and ask you if you recognize that picture.
Yes, I do.
What is that a picture of?
People outside on the deck.
And was that picture taken when Miss Childress was over at the home?
Yes.
And it was taken then during the month of March?
Yes.
Okay, are all these pictures a fair and accurate depiction of what you see over at the house?
Yes.
I notice there are blinds here that are in the picture. Whose blinds are those?
Those are my kitchen blinds.
Okay, and you're taking these pictures from your kitchen, correct?
There's some from my kitchen, and then to get pictures of the cars in the driveway, I take them from my bedroom or my daughter's bedroom window.
Did you feel like there was some questionable activity going on over at the house?
Well, I noticed that things had changed considerably after Claiborne, was removed from the home.
Did you see this type of activity going on when Mr. Claiborne had the home?
No.
Collective one, Judge.
Collective exhibit 1. Markham A, B, C, D, yes.
Three. May I approach again, Judge?
You may.
Show you. Might help if I showed you. I'm going to hand you 3 this time. We'll do it this way. I want to hand you these photographs and ask you if you recognize those photographs.
Yes, I do.
These photographs that you took.
Yes,
And did you take them from your home?
yes. 2 of them, one was taken from my bedroom window, one was taken from my front porch, and the other one was taken from my mailbox.
Okay. And you described to the court what we're about to introduce here for the court. What are these pictures of?
Oh, these pictures
Yes,
that
ma'am.
you gave me? They were pictures of some of the various vehicles that have been over at the house.
Just, it's fair to say this is like a random day in the life of your next door neighbor?
Yes,
Collective 2, Judge.
Exhibit 2 collected.
I'll renew my relevance objection, Judge.
And we would- I'm assuming you're introducing these to show the use and possession of the house and what it's being used for during the time that the defendant has possession.
And the waste is going on over at the house, and, you know, we just don't know.
It is
So
for that reason, Mr. Baker, I'm allowing it to be introduced. Did you get them?
if I could approach Judge, show you this picture and ask you if you took that picture.
no, I didn't take this picture.
What is that a picture of?
I will object to that. She didn't take the picture, she can't authenticate it.
Well, of course you can. You can authenticate it as to whether or not it represents true and accurate representation of what she observed on a particular day. I don't think it requires that you take the picture before you can authenticate what it is. Overrule the objection.
So this is a picture of the bags and boxes that were outside of the home one day. This was just one of the occasions.
Did you see that yourself?
I did see this myself, but I did not take the picture.
Right. But is this a fair and accurate depiction of, looks like a lot of trash and a lot of boxes and things that are just being discarded out of the home?
Yes,
And does it look like quite a bit of stuff?
it does look like quite a bit of stuff.
Next exhibit, Judge.
Exhibit 3. Ready, Mr. Holly?
I am, Judge. If I could have just a minute. I have the color photograph of that. I don't know where I found it. Oh, we'll do the black and white. I understand, Ms. Johnson, let me show you these 3 pictures. I want to ask you if you recall the day that these pictures were taken?
Yes, I do.
Did you take these pictures?
Yes, I did.
And what do these pictures appear to be?
They are pictures of Chris Claiborne's truck being towed off the property.
How did you find that day that his truck was being towed off of the property?
Extremely odd because, so may I back up a minute?
Go ahead.
So I was first contacted on the 6th of March by Mr. Claiborne's daughter, Sydney Claiborne, letting me know he had been removed from the home.
I will object to the hearsay.
Holly, you have any exception, sustained?
You can't testify about what somebody said, but you can testify as to why you saw the
Okay.
picture to be unusual, okay?
Well, I felt that the pictures were odd. There were new cars that are showing up at the house. Here, his vehicle is being removed. Boxes are coming in and out. Trash is put outside. So it was unusual.
Next exhibit, Judge, and I'll link that up with some of Mr. Claiborne's testimony as well. Since she took the pictures, I want to show you a document. I want to ask you if you recall this document?
Yes, I do.
And what is this document?
This is an email that I sent to you on the 29th of March with a text message that I had received from Amy Childress.
Okay. And can you read the email into the record?
Yes, the email, I said, do you think this is something I should go to the police about? Her text message says, "Hi Jerry, this is your neighbor Amy. I just wanted to reach out and apologize if you feel I have annoyed you in any way. I've been nothing but kind and supportive, asking if y'all ever needed anything. I apologize for all the cars coming and going, but it is for my safety and I have not had one party. Also, I have had no more cars in my driveway than you have. There were more vehicles in my driveway when Chris lived here. I will try and get the yard mowed if that is an annoyance as soon as I have the funds. I would use our current yard guy, but Chris still owes him $400 from not paying last year. That being said, Reese Hawley has made it known to many that you are taking pictures of my home and the cars coming in it. I also saw the pictures yesterday from the stand on Reese Hawley and Chris's table. Detective Lovell is also aware you have admitted to taking pictures to Reese Hawley. That is a direct violation of an order of protection and bond conditions that you are fully aware of against my husband. Some of the pictures taken are also of off-duty police officers and security, just so you are aware. I am asking you to stop taking pictures of my home and communicating anything back to my husband or his attorney in regards to me or any activity at 5278 Highway 70 East. Per law enforcement, Chris is no longer a resident at this address currently. If this does not stop immediately, I will call the police and get the detective and DA involved. I have also made my attorney aware of the situation, and he will move forward with legal action next. This is also to make you aware you are not allowed on my property, and if you are, I will file charges of trespassing as this is your official warning. Please do not respond back to me. If you feel that I am being an annoyance at any time, please reach out to the police and they can handle it as they are fully aware of the situation.
So when you received this email, how did you take this email?
Well, it was a text message and
Text
she
message.
sent it to me from both of the phone numbers I have for her. I took it as a threat.
Had you already been to court? This was on Wednesday, March 29th, correct?
That was the day after the first court hearing.
Okay. And the first court hearing, you're talking about the hearing in White Bluff City Court?
Yes, sir.
Okay. And you showed up there to be a witness
I was
for Mr.
subpoenaed
Weber?
there to be a witness, yes.
And you felt like she was sending you this after that court appearance?
Yes.
Am I understanding this right? This neighbor is creeping out her blinds, taking pictures of everything the neighbor is doing, reporting back to the husband, using it against her in court. She writes her a letter asking her to stop and telling her that she'll correct the things that are wrong. And if there's anything really wrong, go to the police and please stay out of my business, which, you know, probably it's not terribly unreasonable. You know, her lawyer probably would get upset about it. And this lady thinks that she's threatening her while she's standing at the window spying on her neighbor. Is she cuckoo for Cocoa Puffs, or am I just not understanding this? OMG.
Did any of the law enforcement at all, the Detective Lovell or anybody ever contact you outside of Ms. Childress at all?
No.
Okay. I would make that the next filed exhibit, Judge.
Exhibit 5.
So it's fair to say that there's issues between apparently Ms. Childress and you being her neighbor, correct?
There is now, yes.
What has that caused you to do in the last couple of weeks, especially since you've gotten this text message?
Well, it's caused my whole family and I to be uncomfortable in our home. We've constrained our dogs so that they don't have full access to the yard very often. We have been in the past, we don't lock our doors. Now we lock our doors. And when I'm away from the home, I turn on the security. If I'm home by myself, I turn on the security alarm.
And who lives with you at your address?
My father, my mother, my sister, and my 12-year-old daughter.
Okay. And have they witnessed all the same?
Yes, they have.
Okay. And how do you, have you noticed that, or whether or not it's affected them in any manner?
Absolutely.
And what have you witnessed about that?
Well, my parents are, I wouldn't even call it paranoid, but you have to understand they are professional dog handlers. And so the dogs that we have are very expensive and they're afraid that their animals will be harmed. They're also concerned about my own safety.
I'm plugged up to the big screen and I'm wondering if there's a button that we could flip. I have a video I'd like to, and this is the end of it. I'd like to play one video that she's.
What kind of dogs do you all have?
Eagles.
We'll show you a video here and I'll ask some questions about it. Did you recall the day that happened?
Yes.
The night that happened?
The night that
pardon me?
happened,
Yeah.
yes.
And when was that? Do you remember?
I don't remember the exact date.
Was it during a time that Ms. Childress had the property or Mr. Claiborne had the property?
Ms. Childress.
Okay.
I can tell you the truck left once and it was like 2:00 in the morning. It returned back about 2:20 and then it left again at 3:00. That was it leaving at 3:00 in the morning.
Okay, and you heard the loud muffler, did it sound like that at your house?
Yes, my bedroom, I sleep with the window open and my bedroom window is the closest to the Claiborne house.
Could you sleep for the truck coming and going?
No.
Did that also affect the other members of your house that evening?
With all due respect, now I do think we're venturing into something that's irrelevant on the possession of the marital residence. I sympathize with her about how it affects her, but going into how it affects her family, I think is beyond the pale.
Fair enough. Your witness. I would move that video in as an exhibit.
Do you have a copy of it to make part of the record?
I've had any other photos on this thumb drive. I would like to have the opportunity maybe to present that to the court.
Until you are, you made a late file exhibit if you want.
That's what I'm asking, a late file exhibit to that, but I've got it here on the thumb drive if anybody needs
You
it.
submitted exhibit 6.
Sergeant, I want to lodge an objection to that. There was nothing established that that car even pulled into this house. It's a car on the road, and they're trying to infer something.
It shows the truck backing up and then it leaving the driveway, and I'm familiar with this location of these two houses. This is the one on Highway 70, right?
Yes, sir.
Towards, almost to Craigie Hill.
Almost to Kingston Springs, Craigie
Almost to
Hill.
Craigie Hill.
Yes, sir.
I know where it is, I know the houses, I watched them being built, so I'm familiar with it, and I understand what she's saying about the fact that a vehicle that leaves at 3 o'clock in the morning would be something she would recognize. Her testimony is that she recorded the truck leaving the home that was being possessed by Ms. Childress at 2:33 or 2 or 2:20 and 3, and I'm allowing it for that purpose.
Okay. Do you know, go ahead.
Her testimony was she was familiar with it. Her sister took the video while she was standing right beside her. So if that comes out that way, I didn't want to mislead the court.
This is a temporary possession, a temporary hearing anyway.
Do you know who was driving that truck?
No, sir.
All right, so why are you saying that that's relevant to that house? Explain to me. An
Because-
unknown truck pulls in there.
Prior to Mr. Claiborne being removed from the home, we didn't have any of this going on. We didn't have unknown vehicles in and out all hours of the night. I didn't have, if they were having a party or such, or, let's say he was running his race car, I knew what the noises were. That's what,
Well, that's kind of, take me through that, because to me, that's specious reasoning. Just because something happens after he moved out, it had to be related to who had possession of the house?
right, but there were a lot of things going on. Items being removed, trash being removed, moving boxes moving in. There were lots of things going on. A truck removed from his parking lot or his driveway. There were
Normal?
lots of, no, that was not normal.
All right, it's not normal for a person having a divorce whose husband got arrested for domestic assault, was served an order of protection. You're telling me that's not unusual?
I did not know about any, I knew that he had been removed from the home, but I can tell you that as much stuff was moving out of that home was not moved in when she moved in.
Why is it any of your business in the first place?
Because I am the neighbor and I look out for my community.
All right, who told you to take these pictures?
Nobody told me to take those pictures. I took those pictures on my own without anybody knowing until the truck was towed off the property, and I talked to my family about it, and they suggested I reach out to Mr. Claiborne.
Well, how do you think it would make the neighbor feel if you had a snoopy neighbor taking pictures of them all the time?
I would hope that if something like that at my house was going on, that they'd take pictures too.
Because you're the standard that everybody should live by.
Judge, I'm going to object. We're getting a little argumentative here.
Same argumentative.
All right, this picture of the two women in the hot tub, what's unusual about that?
Usually the hot tub is run at night when the lights are dark and nobody's there.
So you take issue with the time of day somebody's using the hot tub.
I was taking issue of all the different people that were in and out of that house.
Do you know these two people?
Nope.
These cars, do you know who these cars belong to?
Only the black Armada, the blue Jeep that you see in there occasionally, and that's it.
Well, it sounds like to me you're more worried about the one car because you don't know who this one car belongs to.
No, there were more than one car.
May I approach the witness, Judge?
Right.
Can you show me where there's another car?
This is another car, this is another car. There's also been a truck, there's been a red car.
Show me the truck in that picture.
It's not in this picture, it's in the other picture.
Now, I asked you how many. You identified two vehicles and you said there's a third.
Right, the Armada that is usually there.
All right. Do you know who the Armada belongs to?
Yes, Mr. Claiborne.
Okay. The time Mr. Claiborne lived there was more vehicles than that in the driveway, correct?
Yes,
The difference is you just don't know who they are now.
exactly.
So this sounds more like neighbor who's in the neighbor's business is worried and complaining.
Judge, I'm going to object again.
Is that not true?
Argumentative, sustained.
Judge, I think that's a fair question. What's the difference between, okay, if I know who the cars are and there's more cars there before the divorce, now there's less cars there, but by her own admission, it's because I can't identify at least one of those cars, something's unusual. I
The
think that's a
motivation, Mr. Baker, in taking the photographs or whatever is what you were arguing about. But she is a fact witness about the activities that have been going on at the house. Her reasons or motivation for doing it is not relevant. What she's been brought in as a witness is to show that this is what's going on. So that's the reason I'm sustaining that the question is argumentative.
All right, I'll rephrase the question. There's less cars there now after Mr. Claiborne moved out, correct?
No, there's not.
Then why a minute ago when I asked you, you said there were more cars there when he lived there?
He has a truck, he has his work van, he has the Armada, he has a boat, he has a trailer. And then on occasion, her blue Jeep is there.
And friends come over sometimes and visit and so forth, correct?
Right, and I usually know those vehicles as well.
All right, so that's the whole problem here, right?
No,
No further questions, Judge.
Thank you, ma'am. You may step down. You may be released from your subpoena.
thank
All right,
you.
next witness.
Oh, Mr. Claiborne.
Claiborne, come around, please. your right hand and face our clerk.
Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
You're Chris Claiborne, correct?
Yes.
And you're married to Amy Childers, correct?
Yes, sir.
When did you get married?
October 3rd, something like that,
What year?
2022.
So this has been a 5-month marriage?
Yes, sir.
If I'm counting on my fingers right. First off, the house, you've seen the photographs. Do you own that house?
I have, sir. Me and my late wife purchased it around, I think, 2016, 15, 16, something like that.
If I could approach Judge,
May.
heard the testimony the last time you recorded got continued. You went and got a true copy of your deed, correct?
Yes, sir, that's the deed that still shows my name on the property and plus my late wife's name.
And that was from 2016, correct?
Yes, sir.
If anything, that's about a 6-some-odd month situation that you've owned that home, 6 years.
6 years, yes, sir.
Some odd months.
Yes, sir. I think it was in June is when we actually purchased the home of that year.
Next exhibit.
7.
7.
You heard my opening statement that you guys moved in December into that home, correct?
Yes, sir.
Was that
Yes, sir.
accurate? I
Yes,
guess
sir.
that's what I'm saying, okay. You know, when you lived there, you heard your neighbor's testimony. What type of wild parties did you have?
Not really many. We had a party for my daughter for, I think it was maybe New Year's or somewhere right around in there, some kind of a party or a Christmas party or something other, and we had a bunch of her friends over there. Generally though, anytime I was going to have anything going on at the home, I'd say, hey, I would talk to the neighbors. We'd always communicate back and forth and say, hey, there's going to be people in and out or whatever, or I'm going to be gone or something other like that. And then a lot of times on the weekends, my daughter, if she was at home, she would have some friends here or there over, but very rarely.
And, I mean, you're familiar with these photographs that your neighbor took, correct? You've
Yes,
seen
sir.
them.
Yes, sir.
Is there anybody in these photographs that you recognize?
Well, when they was first took, no, but after the fact, after I found out who one of the girls was that was in the hot tub, I did know, then I know who that is now, after the fact.
Does that cause you concern with your house being used in that fashion?
It does, because it's a brand-new home, and you're seeing so many people come in and out of the home that I don't know what's being brought in and out of my home, what's being done to my home. I mean, there's a lot of valuable things in that home. I mean, there's like high-dollar TVs, there's weapons in the home. I mean, there's all kinds of stuff in this home. There's all kinds of jewelry in the home. I still got a lot of my jewelry there that's not got removed from the house. Some of my late wife's wedding bands and stuff are still there. That's thousands of dollars worth of stuff in this home that's just sitting there with all these people coming in and out. And I have no idea what's going on inside that home now.
And to be clear, when you were living with Miss Childress during the 90, I guess, or so days, more or less, that she was there, did y'all live like that?
No, sir. No, sir. Like I said, we had the one party she catered for my daughter. I think it was like a Christmas party or something like that, some kind of a party, and we had a bunch of her friends over there. Other than that, the whole time we lived there, Miss Childress never had one guest come to that home because of her that I can recall that she knew. Most of her friends, whether they live in Nashville or her sister lives out of town in East Tennessee, and I don't even met her once at a wedding. So other than that, I had some of my family members would come over, like my aunt would come every couple of weeks and clean the home or something like that. They had the yard guys, about it.
So you had business credit cards.
Yes, sir.
Do you have any concerns as to how they've been used by Ms. Childress during this time?
Yes, sir.
Tell the court about that.
I had looked down one day on my phone, and I was just thinking, well, I haven't checked my business. One of my business cards, I carry 2 Chase cards and a American Express card for work. And I logged into my Chase app to see if there was a payment due. And then all of a sudden, this was the week after I had left the home. And I looked down, and all of a sudden, it's showing over $4,000 in Amazon purchases made in 1 week. So I got chased on the phone, and I shut the credit card down and trying to figure out what's going on. Where is these over $4,000 in purchases coming from? And they told me that I had to contact.
Objection, hearsay.
No, it would appear to be hearsay.
I would
Can't
say-
repeat what somebody else told you.
Judge, that, this is for all intent and purposes, a business record. It was a business credit card that he has, and he's looking at his.
That, but what you're asking him to repeat is a statement made by someone at the credit card company you want him to repeat what someone else told him to introduce that statement as true, right?
Well, are you trying to say what somebody has told you, not what you saw?
All they told me who to contact.
You can't testify to what somebody told you. Let's leave it there. Okay, keep going.
So I looked and seen that the charges were all Amazon charges. So I called Amazon, and on each one of the charge, on each charge, it had like a HQ number, H number on it. And I asked them, I said, "What is this charge?" And they told me what each
Judge, I'm gonna
purchase.
object to the
You can't
hearsay.
testify what they
sorry.
told you.
Okay.
But based on your phone call with Amazon, then, what did you do next?
I shut that card down, and I flagged it off as fraudulent activity because it was nothing that I had purchased.
When you look back over your business card and the Amazon statements, what type of things were being purchased?
A vacuum sealer, dish sets, curtains, some kind of a reef was being purchased. There was soaps, there was a mouthwash rinse thing bought. It was just on and on. There was cases of dog food being bought. It was just stuff that I would never even think about buying. It was just purchase after purchase after purchase of just different things.
Right, and according to
It
the
was like
statement.
it was movie subscriptions. It was Amazon subscriptions, and I'm like, it just went on for like 5 days of these purchases just went on.
And again, with your business account and that situation, could you tell where all the stuff's being shipped to?
Yes, sir, I could. It was being shipped to the house,
And
to my house.
Did you order it?
No, sir, I did not.
Did Mrs. Childress have any permission from you to use that account for those purposes?
Not for that, no, sir.
The forklift company, we'll strike that. May I approach?
You may.
Look, I want to show you a document and ask you if you recognize that document.
Yes, sir, I do.
That's a document that you put together that shows what?
It shows all of the purchases that was made from 3 different credit cards of mine. That some of the credit cards that was at the house, not even in my possession. Like the one from AT&T, that card was at the home when there was $1,100 was like charged on it in one day. And then Dixon Storage, there was $1,600 charged in one day, back-to-back charges.
You heard Ms. Childress testify at White Bluff City Court about that.
Yes, sir.
What did she say about those
She
charges?
said that she felt that she needed to go pay her storage unit up for I think it was like 9 months. Was something, I believe it was 9 months is what she testified to.
Was there an Instacart purchase
There was
on
an
there?
Instacart purchase on there.
How much was, what was that for?
Are we still on the possession of the house, or were you talking about debts?
Well, these are credit cards that were at the house, and one of the reasons, after she's taking over the house, one of the things she's going through and finding, and, based on her being able to have access to the house, is actually using it. And it's gonna equate to about $7,000 in 10 days. The court's interested in that, fine. If you're not, I'll move on.
I just think we are limited to what the motions are, which is possession of the house. Unless there's a motion down regarding the assessment of debts and so forth. Now, obviously, there's a restraining statutory injunction, that prohibits things, but.
I'm offering to show waste at the house, because there's no other person that could have gotten these credit cards and used them in such fashion. it certainly implies that she's, went rifling through the drawers and things and found some of this stuff and flat taking advantage of it. Let me ask you one question, I'll get off of it. The Instacart, is that for groceries?
It is. It was. It showed to be two purchases, one for $538 and one for $309.
When you researched that, where was it delivered to?
It was delivered to the front porch of the residence.
Did you make that purchase?
No, sir, I did not.
Judge, I would ask this to be the next exhibit.
I'd object to relevance, Judge.
I'm sorry?
I'd object to relevance.
He's made his argument as to what's relevant, so I'll allow it for the purpose of showing any waste that's occurring because of her possession of the house.
The forklift company that you own is C&K Forklift?
Yes, sir, it is.
And what's the C and the K stand for?
Chris and Kim.
So that was a company that was how old?
Reverently 5-6 years old now.
And I'm assuming then, because of the name, you and your deceased wife started that company?
It was formed solely in my name. I'm sorry, I get upset when I talk about her. It's always been solely in my name, but she done all the billing to the company, a lot of the communications back and forth with the customers, and stuff like that. When it comes to any kind of daily businesses.
So what's going on over at the House Inn in regards to your business? And we've alleged that you need in the house to keep up with your business activities. Tell the court how you use your home for your business and why you need to get possession of the marital residence for your business, okay?
As of right now, it is costing me more money out of my pocket to run the business than I'm making off of the business, because a lot of the stuff that I have in the garage is stuff that I keep pre-ordered and pre-bought, as far as like service and stuff, filters and oils and all kinds of stuff in the home that I have to turn around. We're talking, some of these filters are over $100 a pop. And, and we're looking, at several of them at times, we're talking thousands upon thousands of dollars just in parts sitting in the garage that I need access to daily. But I never know from day to day what I'm going to need unless it's something we already have pre-scheduled service. I get different calls for different stuff every day, but it could be something that I have in the home that if I don't have it, I'm having to turn around and go order it from somewhere else. And then so now that I'm out money double for what some I've already purchased that I had at the home.
I'm trying to say, sometimes you don't know what you need till you get on the scene of the.
Yeah, unless it's something we do routine maintenance on. I keep filters and stuff at the house for like routine maintenance and stuff on certain accounts that I do on a regular basis, like every 30, 60, or 90 days. But any other stuff like that, there's all kinds of like miscellaneous odd and end parts inside the house that I've kept over the years, stuff that I need access to when I do need them. But the filters and stuff that I have to have on a daily basis, if that customers due to be serviced, I keep all that stuff pre-bought ahead.
So has strike that. Do you know if how have you been living since you were removed from the home due to the domestic bond conditions and this order protection?
I have spent.
I'm sorry?
Objection to the form of the question. There was about 3 qualifiers in that question.
I'll rephrase.
Rephrase your question.
Where have you been living?
I've stayed several different places. Some nights I've had to stay in a motel. I've had to stay at some of my late wife's families. I've been staying with my aunt, which was one of the employees that works for me. I've been staying with them. I've had to pretty much almost just be homeless for the last month. I've been homeless, and it's live from place to place.
Do you have like a mother, father, family support around here that you can lean on?
Just my aunt is really the only one that's been able to stay with.
Do you know if Ms. Childress, in your relationship with her, however brief, do you know if she has funds to go and get a place?
I've witnessed her receive a check for about $18,000 or $19,000 from the VA for her father's estate. That was money that was left over in the VA that she deposited into the bank. And then numerous times when we first started dating, she had sold her father's home and collected the money off of that. And she had told me that she had put, I think, $30,000, $40,000 in cash down on a Jeep, and then she'd put another $20,000 into the Jeep. And then she had turned around and wrote a check, I think, for maybe $20,000 to the guy that she sold the house to turn around and rent the house back for a year, because that's where she was living when we met. And that's why she didn't move into my home until December, because the house was still paid up for the year. And then amongst that, she had took and went to Florida and bought, she told me, upwards of $10,000 in plants for a business that she was running. And then I think that last December or early January, I had took her to a plastic surgeon in Nashville, and she paid for breast implants, which was about, I think, $8,000 to $10,000. She wrote a check for that day. So she has a lot of money. It's just she's got it put away where it's hard where she doesn't want anybody to see it.
You've heard her talk about the Regent's bank account when we were in White Bluff City Court,
Yes,
correct?
sir. Yes, sir.
Did she ever answer the question about?
No, sir, she would not answer how much money she had in the bank. She kept saying, I know she has more than one Regent's account. I think she has about 3. From what I've seen her over the times, when she would help me pay some of the bills at the house, if it wouldn't go through on one account, she said, hold on, here's my other card, or I need to transfer money from one account to the other. So she has multiple bank accounts through Regions.
Do you have knowledge that she has reliable transportation on her own?
She does. She has a 2017 Jeep Wrangler. There's really nothing wrong with it. She's just, from my understanding, from what I've been hearing and seeing, that my daughter has been driving the Jeep everywhere around Dixon County and up towards Cookville and East Tennessee for the last month.
And what vehicle has she been using?
My wife now?
Yes.
She's been driving my late wife's Armada.
Okay. Are you aware that Ms. Childers has a GoFundMe page?
I do. I was made aware of that yesterday. That for reasons I was told why it was made, and then those are not true reasons.
That's all I have.
Baker, you may cross-examine.
Well, how much money is in these Region Bank accounts that you say exist?
One of them, she told me she had, when we first got together, she told me she had around $100,000 in it
And when was that when you first got together?
about a year ago.
About a year ago. How much is in it now?
Sir, I don't know. I'm not on none of her accounts, and she's not on none of my accounts as far as when it comes to banking.
You don't know. The only one that knows your
I can
wife's
tell you,
condition is.
I know how much was in the one account when she received the check in the mail, when she got the check from her father's estate. I know that check was put into the bank. So I know the amount of that check. It was around $19,000.
Well, the truth is, these things you complain, you're trying to point out here about the breast augmentation and so forth, those were all prior to marriage. Correct?
So yeah, most of them were, yeah.
Yep. So that money was spent prior to marriage, correct? And this Jeep Wrangler, your daughter's driving that, and the only thing you left your wife to drive was the Armada, correct?
I was told that night that she had to have one vehicle there to drive, and I said she has a Jeep in the garage. She argued the fact about that, and then they made me leave the Armada.
All right, so this Jeep that your daughter's driving is the one that would be $30,000 to $40,000 was spent on, according to you?
That's what she was telling me. She had to put it down. She put $30,000 or $40,000 down in cash when she bought it, so she could get it financed because she had just filed bankruptcy.
All right, so she put a $30,000 to $40,000 on a 2017 Jeep a year ago?
When it's been about 2 years ago. It was before we met. She'd already done it.
Well, 2 years ago would have been 2020, correct?
But she had
21?
told me she had received $200-something thousand off the estate of her dad when she sold the home. It's what the house sold for. Now, I guess that would be public record to find the exact price.
Okay. Where are you getting these numbers?
I'm from her. I mean, I don't know. That's what she's telling me.
Okay, so the probate's still not open.
I don't know. I've not spoke to her in a month. I don't know what's going on with that. And I know she received the check from the VA of the money that was left over in his account.
Well, let's get back on topic. Name a single thing that's been damaged in that house since your wife's had possession of it.
I've not been on the property in 30 days. I couldn't tell you.
You don't know a single thing that's been damaged, correct?
Not that I know of, because I haven't been on the property.
Then why are you claiming waste?
Well, I mean, from the pictures I'm seeing, there's been all this stuff being toted in and out of the house. There's all these people coming in and out. There's been over $8,000 in credit card charges made. And if you're buying $800 or $900 in groceries, I mean, how does one person need to live off $800 or $900 of groceries? And you're buying, or all these people, are you having parties over for other people? Who are you buying $900 worth of groceries for?
truth of the matter is you're just worried because you don't know what's going on over there,
Sir,
right?
hey, like I said, sir, I just want my home back. It's my home. I've had the home prior to our marriage, and, you know, I just don't want what I own and what me and my late wife worked for destroyed.
Was you and the neighbor in collusion on the pictures?
Sir, I did not meet her till a couple years ago till she moved in.
Did you have your relative that worked for the police department, did you have her casing your wife?
No, sir, I did not.
Was he recently terminated?
From what I understand, he was terminated, but for some images that was found on his cell phone, from what I'm understanding. I don't know the whole details behind it.
Okay, well, let me go through this. Do you know who made these charges on here?
Yes, sir, I do. I was told. It's who I was told by Amazon who made the charges and whose account they was purchased off of, I do.
Okay. Well, I want to go through here. AT&T Wireless, there's 2 charges on there. Tell me how that affects the value of the house or any waste of that house.
Well, for one, that card was in the house and that purchase was made while I was sitting in jail for something I didn't do.
Do you know what waste of property is?
There's probably different definitions of it by everybody.
Well, waste of properties for lawyers means that you're doing something to diminish the value of that real estate. Show me something on here that diminishes the value of that real estate.
Judge, I'm going to object. That's not the definition, and that's not what it was offered for. I've already said what it was offered for as far as what's going, rifling through the drawers and pulling up the credit cards, and that's the reason why it's being offered. Those cards should have never been used. It was one of those situations where she or anybody with access is charging, and that's the waste part of it.
Mr. Baker is right about one thing, and that is that waste as it relates to real property is one thing. Waste as it relates to dissipation of assets in the divorce of personal property and monies is a different thing. You don't call it waste, you call it dissipation of an asset. But you introduced this information on the idea that those credit cards were there and in the house, and this is what they've been used for, which I don't think goes to the issue of possession of the house. I think it's irrelevant. So I am overruling your objection. You brought it up. Mr. Baker can question about it, but none of it's relevant about the possession of the house.
Well,
It goes to the question of dissipation of assets regarding the personal property and economic aspect.
Okay, well, hold on.
We talking whole
Let
lot
me
of
back,
me or whole
yes,
lot
let me
of
back up a minute. So that we're not considering this going to the house, because if it is, I'm going to quit asking
I'm not
questions.
considering that as the issue.
Okay, then I've got no more questions about that. Kind of threw me when you got me on my relevance objection, so I thought you were
It
going
threw you
somewhere
that I
with it.
sustained your position.
Yeah, well, no, the previous one, when this was introduced, I object to it for relevance, so then I'm like.
Well, I allowed it, but then
Yeah.
it had no real relevance to what
Right.
I have to decide after reviewing the file. The only issue before me is possession of the house. I don't think it really relates to that, so.
Okay, and then that wraps up my questions, Judge.
Anything further for this witness?
No, sir.
Thank you, sir. You may stand down.
Thank you.
Sure. Holly, you may call your next witness.
I have a moment with Mr. Claver, please.
Mr. Holly?
We're good, Judge. That's all I have.
All right. Mr. Baker, you wish to call any witnesses?
I'll call Mr. Childers briefly, Judge.
Mr. Childers, you will come forward, please. Raise your right hand and let the clerk place you under oath.
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God.
Yes, ma'am.
May sound redundant, but state your name for the record, please.
Amy Lee Childress.
All right, Mr. Childers, when did you move in with your husband?
It was closer to the end of October.
He testified December, but your recollection's October?
That's correct.
All right, now, I want to stick straight to the topic. Why do you need possession of that house?
Because, and I don't want to own the house. However, I do need time to get out of the house. I need the financial funding, basically where I was at prior to living in the house. And he would not let me go back to work. He wanted me to work for C&K Forklift and gave me a handful of credit cards for me to use as money. And I have $594 coming in a month, which is my dad's state retirement.
You have any other source of income right this minute?
No, sir. Everything else is tied up in estate of Terry Childress, and there's, like I said, a pending lawsuit.
All right, how much money do you have in bank accounts?
I do have three Regions accounts. The first two accounts, each one of those have less than $200 in them. I couldn't tell you the exact number because I've had to shut off all my online banking as well as my cards, and as well as the estate of Terry Childress. That is the check that Chris was referring to, because nothing's been paid out yet.
All right, did you start a GoFundMe page?
I did not start a GoFundMe page.
Did somebody start one on your behalf?
Yes, sir.
Okay. Do you know who did that by chance?
Yes, sir. It was actually Chris's daughter, Sydney Claiborne.
Okay, gotcha. All right, now, you realize, your husband's gonna get the house back, obviously.
Absolutely, I want him to.
Okay. But how much time are you needing to get moved out of the house and get ready?
If I've got the resources available to me, I can be out 30 days or less. I want to be out based on the pictures that are being shown. I'm stopped nonstop.
All right, what was your financial position when you came into this marriage?
I had a job making six figures. I was an engineer. We're right at six figures. Of course, I had my dad's estate money coming in, and I had I don't know, probably $50,000 or so. I did have money in savings. However, we've blown through that.
What do you mean specifically? What do you mean since October? What happened to that $50,000?
Well, I had the $50,000. Chris and I dated for a year and a half, and I paid for everything. Or we would go places and I paid for every trip. Or we would go to the store together and he would not bring out his credit card. I would bring out my debit card. So I paid for a lot of stuff and lost a lot of money.
Okay. Give me the total amount of money you think that you've got right now access to.
That I currently have access to me. $400 is what I've got in my bank account, and I have, I believe, $600, and that's set aside to continue to retain you.
Okay. How much was your lease that you terminated when you moved in with your husband?
$2,400, I believe.
All right. And were you still at Electrolux at that time working in engineering?
I was, correct. I was technically it was HCL. I was a contract engineer for that company, Electrolux.
Okay. All right. So we'll get back to the question, because ultimately the question is how much time do you think it would take, or money, to get you back on your feet, to get you moved out?
If I had basically $3,000 a month, which would cover a house for 6 months and utilities until I can get a job again and get packed up, I'm willing to go sleep on someone's couch and be out of there within 30 days. However, I do need funding until I can get a job. I have to have resources.
Gotcha. You got any other relatives close that you could live with?
I don't. I had a mother, or she was like a mother of 20-some years. She passed away in May, and then that was our neighbor. And the following month, my father passed away in June.
Okay. And do you think you could, and I know we don't have a crystal ball, do you think that you might be able to have employment within 60 days?
As long as I'm not tied up in a courtroom nonstop, yes, sir. Sorry.
All right, fair enough. And nothing's been destroyed in that house?
Absolutely not. And if anything, I've been cleaning the house, and I've been moving his late wife's marital property from storage back into the marital residence and placing the items where they were at prior to I moved in.
Okay. Now, that picture it looked like some trash bags or something outside the porch. Maybe it's pizza boxes. What was that?
So Chris hardly took the trash off. It was Logan Brown that always took it off.
Right.
I did not feel safe leaving the house. So the night that Chris was arrested, I threw all the trash that he had previously piled up in the garage. I threw it right outside the garage door. I shut the door, and then Logan Brown picked it all up in his truck or trailer and hauled it off the next day.
All right. The white pickup truck, do you know anything? Who was driving that white pickup truck?
The one with the muffler? Yes, sir. It was Curry Hicks.
Is that a deputy?
She works for the county jail. Yes, sir.
Okay. And you know what she was checking? What was she doing out there?
I've had a lot of friends reach out because I am in fear for my safety, especially when I've seen what I've seen, and I won't go into it because there's an active investigation with the city of White Bluff. However, she had came by the house because she drives by Jeremy Duke's house on the way to and from work, and she left at that time of the morning because she wanted to make sure that my husband was not living there, which was a violation.
All right, and it was Mr. Dukes, was he at the White Bluff Police Department?
Mr. Duke was not at the White Bluff Police Department. Mr. Duke was at home with Chris Claiborne.
Okay. All right,
And that's my understanding, is what she told me.
okay. Mr. Holly, may I ask you some questions?
Okay.
Holly?
So, all right, Ms. Childers, is it fair to say then you're capable of making 6 figures a year?
Yes, sir, I am very capable if I have the time and I'm not tied up in a courtroom nonstop. I was in a courtroom personally with you twice last week and preparing and working with investigators and detectives. That's my full-time job right now.
This happened like the 5th or so of March, and we just started court last week. What have you done from like the 5th or 6th of March to last week to find a place to stay?
Like I said, I've been working on packing up items, and my charges, which were made with a card with my name on them, I had purchased storage units to pack up my belongings, and then I was issued a restraining order from you not to move anything out. So do I move out? Do I stay? So that's where I'm at. I will confirm and tell you, I absolutely do not want the house. I do not want to stay in the house any longer than 30 days. I just need arrangements to get out of the house and the funds to do so. I do not want to be there.
Well, all fairness, it's not your house.
It's not my house.
Have you ever told anybody that you were going to stay in that house forever?
I have not, but actually I have a recording of my husband saying if I would go make a false police report that he would put my name on the deed.
Did you ever tell, you know Pat Jones, you're familiar with her, correct?
Yes.
Did you ever tell Miss Jones that you're going to stay in that house for as long as it takes?
Nope. Absolutely not.
So if she comes in here and says that, then she's not being very truthful.
That would be a lie.
Asked and answered.
Sustained, I believe it was asking.
You said that you had, in previous testimony, White Bluff City Court, you said you had ordered a lot of that stuff on Amazon, and you agreed that you were getting curtains for the house, correct?
And that is correct.
So if you're not doing anything unsafe, and the reason for that was so that your neighbor couldn't see in.
The reason for that is based on the number of pictures that have been taken of this house. I did not feel safe, especially since she's communicating with my husband and there's an order of protection and bond conditions in place.
You lived over there for a long period of time without those curtains on those windows, correct?
Yes, and I complained about that then, and my husband said we would get blinds and put up.
So if you're not doing anything unsavory in that house, why would you need those curtains?
Again, like I said, because there's an order of protection, there's bond conditions out, and like you clearly made available to the court, there are a lot of pictures of my every move being taken.
You didn't like that, did you?
It's not that I don't like it, it's creepy. Because the amount of time that those girls were in the hot tub was maybe 5 minutes. And you have pictures of every vehicle coming in and out of my driveway, including Mr. Claiborne's own half-brother, who is a police officer with Mount Pleasant, who came by the house to go meet with me in Detective Lovell. So yes, it is creepy, which is why I want out of the house.
May I approach?
May?
Sure, I want to show you a document and ask you if you recognize that document.
Yes, sir, I do.
That's a Facebook post.
It is, absolutely.
And that's your Facebook post, correct?
Yes,
And you posted this.
yes.
And there's a photo in a frame. And who is in that photo?
That is Chris's late mother, or late wife, I'm sorry.
Wife, yep. And there are 2 wedding rings in front of that photo in a frame, correct?
That is correct, the 2 he never wore.
And you posted some words above that, correct?
Yes,
Can you read those?
Judge,
You-
I want to object to the relevance of
What
this.
is the relevance?
Yeah, it's going to waste. This jewelry, and I can bring him back up later, but these rings were at the house, and these rings
This
were,
is not about possession of the house, this is about, you're talking about personal property now.
well, personal property should be at that house, and that's,
Personal property, real property. We're talking about real property, not personal property.
Okay.
Sustain the objection.
All right, if I could approach. But you're not trying to get even with him just because you own the house to put this kind of stuff on Facebook, are you?
I'm doing that because he kicked his daughter out of the house in basically the same manner, no car, no vehicle, no resources. And I am supporting his daughter as well as his daughter is supporting me.
And you're going to get even with him because of that?
I have no reason to get even with
Do the
him.
activities you're doing now?
No, sir, I have no reason to get even with him. I simply want out of the marriage.
I'm fine. Thank you, Judge.
Redirect.
You think 90 days you can be out of the house and have a job?
As long as I'm not tied up in investigations and courtrooms, yes, sir.
Fair enough. No further questions.
Thank you, ma'am. You may step down. Mr. Baker, you may call your next witness.
That's our witnesses.
I hear you improve in argument.
Well, Judge, briefly, it's his house. We've established that. Been his house for quite some time, him and his late wife's house. You see what's going on over there. The neighbors are, for all intents and purposes, terrified of what's going on next door. And that's not the way that Mr. Claiborne lived. That's not the way this should be going. And there's some reasoning for that, and hopefully we brought that about. But there is some waste going on. Hopefully we've showed that with these photographs. And Mr. Claiborne, again, this is his separate property, and he's entitled to get it back. We're not here on spousal support. There's been no motion filed. There's no notice opportunity to be heard on her with any spousal support. I have opportunity to bring in his income and expense statement. We've got plenty of time to do that. We obviously have a order of protection that we have to try, and we have to come in here for some sort of, division of marital debts, a spousal support argument for her, then so be it. But right now, she has the means to get out. She's got that Jeep. She's more or less already packed everything up, it sounds like, at this point. And Mr. Claiborne needs his property back. He's homeless, and the business depends on him to be able to get into that house to make a living. He's got much more need for that house than she does at this point.
Judge, the husband has left the wife in a lurch here. You know, we're roughly 2 weeks out from filing this petition. You know, you couldn't even get notice on a detainer action by statute this quick. I think it requires 20 days to even get to a hearing on a detainer action. And the husband is now run into court. Ooh, I want to make my wife, who now I had to quit her job, I want to throw her out in the street with no income, no money, no place to live, and no means to support herself. Judge, I'd ask that we be awarded temporary possession, at least on a 90-day interval, and we revisit this if necessary till she gets back on her feet.
Well, Mr. Baker brings up a detainer action, and essentially that's where we are. This is a marriage of some 5 months. Clearly, the proof established without question or doubt that this property is a separate property of Mr. Claiborne. Ms. Shortis has obtained various things in the way of like an order of protection, which is not before me. It was pointed out, and I certainly have examined this file numerous times this afternoon. There is only one thing before me, and that's possession of the house. Mr. Mr. Claiborne is the owner of that property. It's acknowledged by Ms. Childress that it's his property. She acknowledges she doesn't want it. She's just asking for time to get out. In a detainer action, once the court determines that the owner of the property is entitled to possession, then the occupant is given 10 days to remove themselves from the property. In this particular case, Mr. Claiborne not only is the owner of the property and has concerns about what's taking place in the property itself, but also it is the location of his business activities that is hampering his ability to operate his business. Based upon all the proof, this court is of the opinion that the temporary possession of the property should be given to Mr. Claiborne. She will have 10 days to vacate the property. There is no motion before me regarding support for her or any other economic aspect of it, and it's only solely a possession, and I'm treating it as a detainer action. And in General Sessions Court, it would be the same thing. She would have 10 days to vacate. So that 10 days is operating as of right now, effective starting tomorrow. In addition to that, the restraining order that's previously issued is modified to prevent her from removing any personal property that might be separate property of Mr. Claiborne from damaging or destroying anything prior to her leaving. Mr. Baker, you have stood up.
Well, Judge, if we're treating this as a detainer, I would ask for at least 16 days since we're required 14 days notice on a hearing on a detainer.
Well, I said I'm treating it. It is obviously not a detainer action, so it was a nice effort, but nonetheless, I'm sorry that she is in such a situation that it may call upon her to rely upon friends and so forth. And upon the filing of a motion for spousal support, then certainly Judge Wallace can give you a hearing date and you can come back in before him on your order of protection or the spousal support and have that heard. He'll be here next month or this month? April's this month, so you probably should check with him. All right.
May I address court?
No. What about?
Well, I know I'm gonna get asked this out in the hall, so if tomorrow's day one, if I'm looking at that right, that would be the 14th, at lunch or
10
5.
days, starts running tomorrow.
And the weekends and all that'd be the 14th, so that'd be, we need a time,
I'm
12.
assuming you two good lawyers can calculate 10 days without me having to do it for you. First day is tomorrow. 10 days from tomorrow will be, tomorrow is the 5th. 10 days from tomorrow is the 15th. That's 10 days.
15th, yes, sir.
She has to be out by 6 p.m. on the 15th day of April.
Yes, sir. Thank you, Judge. Put it in order.
That is the judgment of the court.
All right.
Childress Claiborne. All right. I want to make sure of what we have pending before the court. So bear with me while I go through these motions and then we'll address them all. First of all, is on April the 19th of 2023, a motion for exclusive possession of a vehicle was filed by the respondent through her attorney at the time, Mr. Olin Baker. I have a motion for pendentiality support, also filed April 19th, 2023, on behalf of Ms. Childress. I have a motion to compel and for sanctions, filed May 18th of 2023 by Mr. Claiborne. A motion filed on May 24th, seeking to prohibit the respondent, Ms. Childress Claiborne, from continuing to post on social media negative inferences about him and his company. I have a motion for violation of the automatic injunction filed on May 24th by Mr. Childress. I'm sorry, Mr. Claiborne. I have a motion for no contact order entered or filed May 24th by Mr. Claiborne. A motion for contempt filed June the 8th of 2023, filed by Mr. Claiborne, seeking to have Mrs. Claiborne found in civil contempt. And lastly, according to what I am saying, is a motion filed by Mr. Claiborne for an order removing her, Mrs. Claiborne, from the party automobile insurance. Have I missed any motion? You have two motions that you filed through your attorney prior to his withdrawal, and then the rest of these have been filed by Mr. Claiborne. Is that correct?
Your Honor, that is correct.
There should also be one regarding a temporary order of protection that was submitted into the courts on March 14th.
Judge, that is a temporary order of protection. Now, that was in general sessions. It was on that day sent here to be heard. We never had a temporary hearing. I would like some clarification to that today. That's not on the docket for today. I'm not necessarily prepared to get into any of that, but I think the TRO's expired because of the timeliness of the final hearing when it gets transferred up. And I expressed that to Mr. Baker prior to his withdrawal, and it never was said. So,
Your Honor,
a little clarification maybe on that would be where I would be.
Your Honor, this order of protection has been tossed back and forth in courtrooms. I've came to court every time expecting that the order of protection be heard. I've not been made aware that it was expired. I simply can't help if the court can't get it before a judge in time.
Well, first and foremost, there is no order of protection. There is a petition for an order of protection that's pending, and we'll hear that today.
Yes, Your Honor, thank you.
All right. Then, under those facts, it would appear that Mr. Claiborne is the plaintiff, so we're going to allow you to go forward with your motions first. And, well, actually, I guess she filed hers contemporaneously, or at least time-wise, hers were filed first. So, Ms. Claiborne, you are representing yourself. If you'd like to come forward and you want to testify.
Yes, Your Honor, I would. And no disrespect, but I would like to state for the record, my legal name has always been Amy Childress. I've never changed it. There's never been any indication that my name is Claiborne, and Mr. Hawley is fully aware of that.
Well, the petition that was filed for order of protection identifies you as Amy Lee Childress Claiborne. I don't know who filled it out, but it was not me. So I will address you as Ms. Childress.
Thank you, Your Honor.
I don't think Mr. Claiborne has any problem with addressing her as Childress.
I don't have any problem with that. I can tell you we've known her as Miss Claiborne. She did a will outside of my office and said her name was Miss Claiborne. So, but whatever she wants to be called today is fine. I have a little preliminary motion before she begins to testify about the support motion. And that is what I kind of talked to the court a little bit about earlier. And that's for my motion to compel her for sanctions, mainly because we've had this discovery outstanding since mid-April. And that was when Mr. Baker was there as well.
What does your discovery motion relate to?
I don't have it. I filed it and I don't have any discovery. Nobody's ever responded to it.
What information are you seeking in your motion for discovery that you feel like is relevant? In other words, what I'm trying to do is to identify what I can address in these motions today. And if you're saying that you have to have the answers to the interrogatories or your discovery before some of it has to be done, that's so be it. But for example, the petition for order of protection does not require discovery, and normally there's no discovery made in that. So certainly we can go forward with that. The next question would be on all of these other motions, such as spousal support and so forth. Are you saying that you must have your discovery responses before you're prepared to do that?
What I am saying, Judge, is that, of course, I don't have it. The financial questions are in my discovery. I believe she has a job. She's asked for, I think, the Armada, which the Armada's been sold. We get into all that testimony, but the bottom line is, I think she has transportation, which I've asked about in the discovery. I think she has a job and an income, money in the bank. There's a lot of financial issues that goes with her motion for spousal support here today. I just don't think it's fair that we can sit on this for what, that's now about 4 months. And if I had that, it would definitely streamline these motions today, I will say that. But long and short of it, I think it's only fair that I get the answers to my discovery, which were due prior to the setting of this motion in the first place, before we come in and want the spousal support. I'd like to have the answers to some of these questions so that I can prepare and put together a defense to this and know what I'm objecting to, what I'm going to allow, what the actual figures are going to be in some of this, so that I can put a decent defense in front of the court and not waste the court's time.
Your Honor, if I may.
You may.
The interrogatories were entered as a response to the final or the divorce proceedings. The motions that were filed were to grant me spousal support and other aid that I might need until that time. I did respond to the interrogatories or the discovery request to the best of my ability However, a lot of these questions are either not relevant, they're being sought to call out names of individuals who are continuing to be harassed through this court system with the information being obtained, as well as there are multiple criminal cases going on currently, and I do not wish to disclose that information until after the criminal trials have taken place.
Well, you don't really have that right. In a criminal case, the only person who has a right to avoid answering questions is a criminal defendant. The defendant has the right, under the Fifth Amendment of the Constitution of the United States, to decline to answer questions that might tend to incriminate him in a criminal action. So you will have to answer those questions whether you wish to do so or not. And under the discovery rules and the rules of civil procedure, if you refuse to answer the questions, then it only gives me a couple of options. One of them is I can hold you in contempt, which I don't want to do. Another is I can order that you have to pay the attorney's fees for the other side, which obviously you're probably not able to do. And a third one is I can dismiss your pleadings in the case, and that allows the other side to proceed on a default basis. None of those are good aspects for your side of this case. So I'm concerned that you need to understand you don't have the right to simply say because there's a pending criminal case that you're a victim or alleged victim in, that you have the right to simply refuse to answer civil litigation questions. You, at this point, have the right to proceed on your petition for order of protection. I am going to allow Mr. Holly to argue his motion for to compel production of documents, if that's how you wish to proceed, and then I'll decide where we are at that point. So on these other motions, you want to come to the podium, and I'll hear you on your motion to compel.
And Judge, may I address the court too on that order of protection? I'm just sitting here thinking, I wasn't prepared to do that. There was no notice that today was going to be that hearing. I've got video basically of what transpired during the entire domestic assault from the outside cameras of the parties. And I don't have that with me here today. We played in general sessions in White Bluff. I think the court may want to see some of these things if we get into this order of protection hearing. And I would need it for a proper defense. But that order of protection, as far as I know, I never got any notice that it was going to be set actually for today.
There is no notice in the file about it.
I'm just asking for a continuance so that if we're going to do the order of protection, so I can put everything in front of the court.
It's not on the docket, and as a result, it's not a question of continuing. It's actually a question of setting it. If you're not prepared, then I cannot force you to go forward on it because it was not set. So we'll have to find another day for that. But let's hear your motion to compel and find out if there's any of these things that I can actually hear today. First of all, are all of these folks that are in the courtroom witnesses, or are they here with the rest of the folks that are here? Are they here on this case?
Your Honor, I didn't
Potpourri of all of that. And I would ask for the rule for the witnesses to at least.
Rule has been requested. That means that anyone who's going to be a potential witness in this case, other than the parties, must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You're to not discuss the testimony of any other person until you yourself have been called to testify.
And Your Honor, I would like to request to clear the courtroom. This individual right here was my childhood best friend. She's been brought in here every time to intimidate me. I would request to clear it.
Don't have a right to clear the courtroom. We are a public proceeding, and as a result of that, unless they're a witness, you don't have the right to. Anyone who's in this courtroom will conduct themselves appropriately. There'll be no intimidation or attempt to intimidate, or I'll have them removed and held in contempt.
Thank you, Your Honor.
But I am simply telling you, you don't have a right to close a public proceeding.
Thank you, Your Honor.
Next thing is that I don't know if the monitors outside were on or off. Would you double check to make sure?
I'll go double check it.
All right, let's deal with your motion to compel.
Well, Judge, as always, these are kind of simple. And my motion states the discovery was filed on the 10th day of April this year. I sent an email to Olin Baker on the 21st day of April asking if the discovery was going to be filed. He already talked about getting off of the case a little bit. I want to make sure I got a letter into him before he left, if he was actually going to withdraw. And I do not have any answers. my standard discovery, ask all the financial basics of the other side. Is there money in the bank? How much money do you have at your disposal? Do you have employment? What is your pay produced to me in the request for production of documents, your pay stub, your tax returns, all of these things that would be beneficial in me trying to ascertain whether or not she would have even a need for discovery or be able to handle the expenses herself for whatever her living condition is. And I don't have any of that. And I don't think it's fair for that to wait for 4 months when this motion was outstanding since, or her motion, I guess, was outstanding from what the court has said. The motion for pendant light support, I don't have the stamped filed copy, but it was signed by Mr. Baker on the 19th day of April 2023 and certified to me on that day. And purposefully, we've had absolutely no attempt to answer these questions. There's none. If the court wants to see my discovery, it may take me a minute to dig it out of my bag over here. I'll be glad to do that. I don't have it on OneNote.
There's a copy of it in the file.
Is there? Okay, so I filed this one. I do some, and then with the Nancy Miller rules, sometimes I don't. But in this case, I did, and the court can very well look at that and see some of these questions would be definitely on point with whether or not she would be entitled to spousal support. I'm not saying she can't bring her motion, but I would just like to have an answer. Part of the sanctions and the motion to compel and sanctions would be that she provide me an answer to this prior to taking this up.
Ms. Childers, you want to come to the podium? I'll hear you on why you should not, why you haven't answered these questions and why you should not.
Yes, Your Honor. Again, at the time that these were filed, I did have a retainer in to Mr. Baker. Mr. Baker did forward these to me. I did respond to the best of my ability. Some of these questions in here are not relevant to a 5-month marriage. Where he's going back and asking things of all of my communication, social media, phones, you name it, from the last 12 months. He's asking information pertaining to my father's estate, which has nothing to do with this marriage. I'm simply stating this is a 5-month marriage. There was no debt. There's no children involved. All I'm asking for is just the spousal support to get back on my feet in a divorce. There's no need to drag this out. I don't have the money to fight this. I truly don't. You see the number of motions that have came at me. I just simply don't have the money. I've tried to get a retainer in order to fight this. I don't have the funds. I just started working in May, and I've had to purchase my own home. Since April, I was given 10 days to leave the marital residence. In that 10 days, I had to sleep on my stepdaughter's chair for several months, had to move again, finally got employment, and that money, it's every penny that I make is going to currently how I live and to pay people back. I simply don't have the money to fight this. I am prepared. Look, I am prepared to sign papers, walk away, and cut our losses. The only option that I've been given by Mr. Claiborne is I can live in the marital residence for 6 months. He would pay all the expenses. However, he wanted me to lower the bond conditions or the order of protection. I do not wish to do that. I've even gone as far as I would walk away with nothing, as well as if he would leave me alone, I would consider going to the DA on this domestic, but it's just not stopping. I just simply want a divorce. We don't have any real estate together. We don't have any financials together. We lived for 3 months together. That was it.
Well, a 5-month marriage, one of the factors that the court has to consider in any sort of spousal support request is the length and duration of the marriage. It also is the separate assets that the parties have and the income that the parties have. So all of these issues are relevant if we have to have a contested hearing. If you're telling me that you're wanting to just terminate your marriage and walk away, count your losses or whatever, I'll take a recess. You and Mr. Holly can talk about this case. If y'all come to an agreement, then so be it. This is not a proceeding whereby we bargain criminal proceedings versus civil proceedings. So, I mean, that's a decision you can make, but it's not part of what I condone as part of the situation. But the district attorney's office is readily available, and if you all negotiate something that you want to resolve so that you're done with Dixon County and can be on your way, then I'll certainly give you an opportunity to do that. So I'll take a short recess and let you and Mr. Holly talk about it, and we'll come back to it. Otherwise, I'm going to have to order that there be an entry of an order regarding the discovery, because it is going to have to be answered under oath. We'll stand at recess for about 15 minutes.
Yes, Your Honor.
All rise.
You have argued your motion to compel, and there's no agreement reached between the two of you, so your motion to compel is granted. Ms. Childress will file her responses under oath, making full and complete answers to all of the questions, or pursuant to the rules of civil procedure, she will file an objection. If you need to access the rules of civil procedure, you can do so online, I think through the administrative office of the courts, but you will either have to answer them fully under oath within 30 days, or you will have to file an objection and state the reason why you do not feel you should have to answer it. Then I will consider at a later date, or one of the other judges will consider at a later date, whether or not you're justified. If you are not justified and have failed to answer them despite my order, then sanctions will be applied. So be careful when you object to it to make sure that you have a valid legal reason to object, or else it could come back to haunt you. I've already shown that the order of protection will have to be, there was an order of protection temporarily issued in general sessions, and it was transferred, but under the law, that order was only valid for 15 days because it was issued ex parte. That means the petition is still pending, but there is no current order of protection in this court's opinion. The issue of your request for attorney's fees on the motion to compel is reserved. Are there any other motions that you wish to address, Mr. Holly, before we adjourn?
Judge.
Seems to me that you can't have it both ways. If you're asking for a continuance in order to obtain this information before you can proceed on some of them, then we'll be resetting everything.
I understand that. What I would say to that, as far as the motions that have been filed, first of all, it's a situation where I have trouble talking to Ms. Childress. I just think we can't seem to communicate. So I'm having to file motions in a 5-month marriage, and that's just where we are with these folks. The motion for contempt for the dogs, the motion for contempt for the Armada, I'm going to pass those. We got the dogs back, we got the Armada back. And a little bit here, the court entered an order April the 17th, and it was from a temporary hearing that we had. Mr. Baker was here. If you recall, there was a witness, a neighbor, that got on the stand and testified about the pictures of the home. It's over there in White Bluff, the end of White Bluff, over by Craigie Hope. The court said you knew where it was.
I know where it is.
Went through the whole thing with her. You found her to be credible, found the pictures to be credible over objection, and ordered that Mr. Claiborne could have the home back. Mr. Baker and I had entered into an agreed order regarding a restraining order that we had filed, and we had an agreement. We had announced that agreement prior to the hearing. This court's ruling, at the end of the day, you went back to our agreed order and said, I'm going to modify that just a little bit for you gentlemen, and I'm going to add a paragraph to the end of it that says that the wife is restrained from removing any of the personal property of the husbands from the husband's residence located at 5278 Highway 70 East White Bluff, and or damaging and or destroying any of the personal property that might or is a separate property of the husband. So that was in place. We got the home back, not on that Saturday like the court anticipated. I didn't get the order, the ability to sign it from Mr. Baker until a little after 4 o'clock on Friday, so everybody's closed. White Bluff Municipal demanded an order before we could go in and hear, or go in and take possession of the home. So we came back Monday with the order. You signed it, and we went back in that Tuesday afternoon and took possession of the home. And an abundance of caution, as contentious as this has been with her putting everything on social media, you've seen the motions, what's attached to the motion for social media prohibitions and things of that nature. We hired 2 off-duty police officers to go inspect the home first to get any liquor, any guns out. The court has said that the temporary order of protection has expired. However, there is some recourse because he still has those domestic bond conditions. We have adamantly opposed that domestic. It's currently set for trial. And Judge Creasy is representing him on that. But what happened when we got the ability to go in the home on that Tuesday, it's been cleaned out. There's all sorts of damage. You're going to hear and see photographs of white powdery substance in the gas tank of the new Harley, water in the gas tank of the side-by-side. Somebody defecated in his clothes drawer. There's urination stains all over the place. There's a whole list of things, TVs, jewelry. We've got about $8,000 worth of jewelry that is missing. We have seen this on different sale sites on the internet right now. I fear that if we don't at least be able to have heard the motion for contempt for the stolen damage in personal property, some 42, we're estimating that to be by our list that's attached to the motion, some $42,000 worth of personal property and damages. The personal property will be just that much further out of reach. So that's a fairly important motion for Mr. Claiborne at this point, whether it's today or a quick reset. But the 2 officers are here to testify about what they found, the condition of the home when they first went in. Then they went in, inspected it. There was some alcohol in there, which they got out and gave to a neighbor friend. There were no weapons in there, so they cleared it for him, and then he came in and took it over. They're here to testify, and we've had to pay them because they're off duty. They're privately hired, and they've been here on both days. It's a little expense to Mr. Claiborne to be able to do that. I just feel like this one, particularly this one motion, needs some attention soon. I'll put it that way to the court. I understand the court's reasoning of what you're saying. I'd like to be able to do it today, or at least be able to put the officers on so we don't have to pay them anymore, if that's a consideration. The posting on social media, the no contact, that should be a relatively simple motion. I mean, if we're going to hear that, I stand on basically what I filed. I mean, I put all the social media posts that's attached. I don't think it's hard to say that, both parties would not have any contact, or both parties would, not put anything on social media, that sort of thing. But we're concerned about the personal property, and it's just and if the court will remember it kind of, the photographs resembled something going on in the Animal House movie over there, and I just, and Mr. Claiborne does as well, want some sort of relief for this personal property, or at least figure out maybe what she's going to say where it is, or if we can get our hands on any of it to preserve it. That's the divorce case. It's a 5-month marriage. They don't have anything else. But that particular motion right there is pretty much our divorce case in full.
Ms. Childers?
Yes, Your Honor, I did attempt to speak with Mr. Hawley. He basically held a piece of paper in my face and said, "Where's my $100,000 worth of stuff?"
I don't care about
Okay.
that. Just tell me, are you prepared?
I am prepared to speak to the theft and damages today. I have video myself, I have witnesses, and I have receipts for
All
everything.
right, then we'll hear that.
Yes, Your Honor. And I would also like to hear on the no contact, I would like to hear that, as well as he had brought up another, he had filed a motion on accessing email accounts previously. He filed another motion against me again. I've turned over that email address. However, I never received any of my account information, and I would like to hear that motion as well today.
We will hear every motion that both sides agree can be heard. So,
Yes, Your Honor. Thank you.
Mr. Hawley, you may call your first witness. This will start with the motion that you filed for civil contempt on June the 8th of 2023, correct?
Yes, sir.
Right.
Hunter England, he's out in the hallway.
you'll step around here, please, and face our clerk and raise your right hand.
Yes, ma'am.
Mr. Anglin, state your full name for the court, please, sir.
Hunter Anglin.
And are you employed with the Dixon County Sheriff's Department?
Yes, sir.
Do you have a chance to do some off-duty work for Mr. Claiborne?
Yes, sir.
Did you have a chance to go out and do a civil standby for him when he was trying to get his home back?
Yes, sir.
And what date was that?
The first time we went was on 4/15/23.
Okay. Tell the court what happened that time.
On the first civil standby, pretty
And I
much.
just say that was a Saturday, right?
It was, yes, sir.
Okay, go ahead.
The first time we went for the civil standby, it was due to a recent court appearance where Judge Wolf had signed off that he could have possession of the property back. My whole purpose for being there the whole time was just to check the house for firearms and alcohol, and that was it. The first time we went, we got canceled because I realized there wasn't a signed copy by Judge Wolf. So I actually ended up canceling the civil standby that day.
And was White Bluff Municipal Court demanding that as well?
From what I've gathered, former Officer Jeremy Duke had spoke with White Bluff or been in contact with them, and White Bluff actually drove by and I said, without this signed paper, I'm not going to do it. So the first day we left.
All right. And then you came back then that following Tuesday, and we had a judge sign, stamp filed order that said Mr. Claiborne could take back the home.
Yes, sir. That was at 12 p.m.
Okay. And explain to the court how you found the house when you went in.
How I found the house, I'd never been there before. So pretty much when I went, we left Mr. Claiborne outside. Sergeant Lashley was already on scene. I did observe him carrying out some alcohol bottles because that was the whole purpose of us being there, was to get the firearms and alcohol out so he would be in accordance with his bond conditions. After that, we went through the house. I did notice a few things. And after we realized that we got everything, we just wanted to double check. So we actually got Mr. Claiborne to come in with us and walk through. But I can't say how the house ever was before because I didn't know either party.
I'm just asking how you found the house when you went in. Was it?
It was fairly empty, honestly. There was furniture. There were big trash bags, I believe, in the kitchen that had leftover crab, and it really made the house stink up. If you got near the kitchen, you knew it. Items were in disarray. I walked through, like I said, just to make sure, because we wanted to make sure he was in accordance. I did observe his Harley in the basement. It had what looked like powdered sugar or something around the gas tank, but like I said, I'd never seen it prior. Couldn't say what the substance was. But anything after that, if you're asking, the house was, it kind of looked like a newly modeled house, really. Like it was empty.
Okay. And as far as you entering the home, are you saying you entered it before Mr. Claiborne went in?
Yes, sir, I did.
Okay. Did Mr. Claiborne have any opportunity to sabotage this house to make it look like that?
I was there on the 15th, and of course I left. I didn't sit there the whole time, but no, not on that day because we had left him outside specifically, so he was not in violation of his bond conditions.
All right. And did you have an opportunity to serve one of the witnesses here today?
I did.
Which one?
Mr. Colin Dever.
Okay. When you served him, what did he tell you about Ms. Childress?
He was very cordial. Mr. Dever was very polite. When he opened the door, I think he was a little bit shocked to see me there. And I handed him the paper and I said, Mr. Devers, you've been served. And he said, is this about that bitch Amy? And I said, sir, I don't know Amy. You'll have to read the paperwork.
Your Honor, I'd object. Mr. Collin is outside. If we could ask him those questions directly.
We absolutely can.
Objections based on the hearsay statement, I sustain the objection.
So, that's all I have. Thank you.
Do you have any questions for this witness?
I do, Your Honor.
Come to the podium.
Deputy Anglin, can you
Yes,
tell me
ma'am.
Can you tell me what time you arrived at the house on 415?
On 415, it would have been after 6, ma'am. It was roughly, I know I was passing Montgomery Bell. I went back on my text messages at 5:50-ish, but I wasn't supposed to be there till 6. And like I said, I'd never met either party involved in this. I was only there just to make sure there wasn't guns there.
Gotcha. Can you specifically speak to the damages that I mean, this list is pretty big, and you said the house was pretty empty, so.
I never made a list of anything. Like I told you, Attorney Holly on that, I never knew what the house looked like before. I didn't know either of y'all.
But there, I guess let me restate it. These 2 deputies, you've been one of them.
Yes, ma'am.
That was hired, is testifying to close to $100,000 worth of damages and items being missing. You stated that the house was pretty much
Judge,
empty.
I'm going to
I have no
object. That
knowledge.
wasn't part of my questioning and wasn't part of his answers to that. There's no way he would even know that.
Stained.
Did you state that the house looked empty when you went through it?
It honestly, Miss Amy, it looked kind of like a house that was up for sale, really, because there was things kind of moved, but most of the cabinets were empty. It's like it had been cleaned out.
Did you interact with Officer Matt Ray with White Bluff Police Department on 415?
I don't know that name, ma'am. Did you say Matt Ray?
Yes, sir.
Who? Never heard of him.
Officer Ray with White Bluff Police Department?
I've never heard of an Officer Ray.
So what other date did you go back into the house?
Are you talking about the first time? I didn't go in the house on the 15th.
That's the second time,
The second time, that was the 18th, ma'am.
on the 18th. About what time?
We were scheduled to be there at 12. I looked back on my text as well to be specific. I was passing in relation the backside of Montgomery Bell just before 12. So I'm assuming I got there around 12:10 probably.
Okay. And so if I'm understanding this correctly, Mr. Claiborne never entered the home on 415, correct?
That would be a question. He did go in after myself and Sergeant Lashley had already went in.
So after y'all had exited the home,
Sergeant
correct?
Lashley was actually inside once I arrived at 12:08, 12:10 in that area, and he was carrying out liquor bottles and giving them to, I guess, one of Mr. Claiborne's family members.
And that's on the 18th.
Yes, ma'am.
On the 15th, did anyone specifically go into the
No one
residence?
entered the house. We did get a complaint about a dog possibly being in there. No one went in the house at all on the 15th, and I made sure of that because I did believe Attorney Holly that he said that the Honorable Judge Wolf had signed off on it, or not signed off on it, but he had ordered he could, but without something doing my job for as long as I have, I'm not going to go in unless I see it on paper.
Are you a client of Mr. Holly's?
I have been in the past.
So that would be your relationship with Mr. Holly?
No, that's not correct. I've been friends with Judge Holly, Attorney Holly for 20 years.
But you are a client, correct?
I wouldn't call myself a current client. My case is,
According to the news media, you are. Mr.
at
Holly.
one point it was.
Object to the
You're
relevance.
kind of going out
It's
there.
relevant to state
You need
the,
to address me rather than him. He's
Sorry.
objecting to the relevance.
Sorry, Your Honor. It's relevant because if Mr. Anglin was hired by Mr. Claiborne as his personal deputy to go inside this house, I know the 2 deputies involved in this case are personally directly connected to Mr. Holly. And there is relevance there. So I would request to allow it.
How does it make, relevance means that something, a piece of evidence that makes an issue more likely to be true than not. That's why it's relevant. What issue are you trying to say? It makes it relevant that he was a former client or a friend or whatever of Mr. Holly.
Because of the law enforcement involvement, Your Honor.
Sustain the objection.
Were you reprimanded by Lieutenant Humphreys or by your,
Oh, absolutely
Administration.
not. They looked at the complaint and said they were frivolous.
okay, so
Your complaint.
Lieutenant Humphreys' text message to me would be
Yours was
Incorrect.
frivolous.
Okay, I have a text message from Lieutenant Humphreys that
Argumentative.
Judge, I'm going to object to the hearsay of that.
Well, number
it's
one,
not, sorry.
You cannot, your job right now is to question, not to make statements or offer evidence. So you can ask questions of this witness, but you cannot state facts as you believe them to be. So sustain the objection.
So you were not reprimanded,
Oh,
correct?
no, not at all.
No further
I was
questions.
told to have a great day.
Anything further?
The door is open. Ms. Childress did file a complaint against you for this civil standby, correct?
I've never met the woman.
Well, I mean, she did file a
Oh,
complaint against you.
she did.
And what was the, excuse me, what did you go through in the process of that with the sheriff's administration?
Oh, about a full support from them, about a 10-minute meeting, and they figured out it was frivolous.
And they took what action, if any, toward her
Nothing.
complaint?
Told me to have a good day.
Thank you.
Your Honor.
Too bad.
If the court will allow it, I have my cell phone out of my vehicle where Lieutenant Humphreys is in fact confirming that there was reprimands
She's
involved.
asking to get in some hearsay.
Well, Mr. Hawley, you went there with it. I mean, you're the one that said that I made these motions against, or these complaints against him, and I do have the evidence that it's not frivolous.
Well,
I got promoted to sergeant.
Everybody stop talking except me and listen to me. Number one, any out-of-court statement you have in the form of a text message is considered to be hearsay and would therefore not be admissible. If you want to subpoena the person that supposedly made that statement, then you can bring them into court and have them testify. But I will not allow you to bring in a text message from another person who's not subject to being cross-examined here in the courtroom and have that brought in to disprove or to prove a fact. So I'm sustaining the objection on the basis of it is hearsay.
Yes, Your Honor, and Lieutenant Humphreys is out on medical this week, and she was not allowed to be here, so if I need to have her subpoenaed at a later time, I will.
Your call, I'm just simply saying your text message is not admissible.
Yes, Your Honor.
Anything further? Thank you, officer. You may stand down.
Thank you, Judge.
You are released from your subpoena. You may go about your business. Call your next witness.
Chris Lasher. Mr. Engel was asking if he could stay in the courtroom and watch.
Public proceedings, and you may stay as long as you like.
Thank you. Thank you.
Come up, sir, and raise your right hand.
Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
You will, for the record, state your name, sir.
Christopher Stanley Lashley.
And what is your employment?
My employment, I'm a Dixie County Sheriff's Patrol Sergeant.
Did you have an opportunity to go to the home of Mr. Claiborne off duty as being employed by Mr. Claiborne to do a civil standby?
Yes, sir, I did.
And that was on a private basis, correct?
Yes, sir.
And you went there on a Saturday, I believe it was the 15th of April, somewhere around in there?
Yes, sir.
And tell the court what happened on that day.
Well, we got up there, got a copy of, we were supposed to go in there, make sure there wasn't any guns or alcohol in the residence.
And that was because of the possible violation of bond conditions, correct?
Correct, correct. And so we got up there and we're looking at the order, and the order wasn't signed. We had to terminate it. We could not go in.
Did White Bluff Municipal Court ask for the order before you could go in?
They did.
All right, and they're the ones that said without a signed order, they're not going to allow that at that time.
That's correct.
Do you have any doubt that if Mr. Claiborne would have went there on Saturday without a signed order, that would have been an altercation between him and the White Bluff Municipal Department?
I'm positive it would have been a violation without the judge's signature or attorney's signatures.
And then you had opportunity to go on that following Tuesday, correct?
Yes, sir, I did.
All right, and explain to the court again what happened when you got there and get into how you found the house and that sort of thing.
On the 18th, how I found the house, I had served a subpoena there before.
I mean, like the condition of the house, how you found the condition of the house.
Oh, okay. Well, the house, it was vacant. Nobody was there, empty. We were concerned about pets being in the house. There were no pets in the house. The house was, it was stripped down. It's like most of the stuff gone out of it, except for the shop area, from what I could tell. Kitchen was a wreck.
How so?
It was just trash everywhere. There was stuff in the trash can it was like food put in there, and it was just a rotten smell to it. After that, we walked around and removed any alcohol that was in the residence. Did not see any firearms in there. And then I had Deputy Angler, Sergeant Anglin, at the time, that's what I call him. But he come in there after me, and, I had him do another walkthrough with me. After that, we went out to the driveway and got Mr. Claver and allowed him to walk through to make sure everything's good, because we took out everything we could find.
Everything you could find being alcohol or gun related?
Yes, sir.
Okay. And based on this, has Ms. Childress, we got into it earlier, has she filed any complaints against you with the sheriff's department?
That is correct.
What was the basis of those complaints?
Basis of the complaints was where I'd met up with her. I had went on duty and served one of the papers on her, because off duty she would not answer the phone or.
Officer Lewis, Sergeant Lewis, pull that base of that microphone closer to you. You can lean back as long as that's a little bit close. There you go.
Sorry, Judge.
That's all right. Go ahead, I'm sorry.
What was the outcome of that investigation with the sheriff's department?
The outcome, there was no policy violation, but the ethics part of it, I was told that I cannot serve anything while on duty anymore.
So have you had an opportunity now that this is all going by? Well, strike that. Is there anything else that's come about this in the last couple of days?
That's correct. I was informed that as one of the news stations wanted a copy of mine and Hunter England's work file or a personnel file.
Okay, somebody complained to the news and?
Yes.
All right, nothing further.
Ms. Lewis, you have questions for this witness?
Yes, Your Honor. Mr. Lashley, what time did you arrive at the residence on the 18th?
On the 18th, it's somewhere around noon, maybe a little after.
Okay. According to Mr. Hawley's motion, there were drug needles, there was people had defecated in the house, supposedly. There were prescriptions missing. Did anyone take any DNA or take any pictures?
I don't recall any of that.
So $100,000 worth of vandalism and items missing and defecation.
I don't object to the relevance of the $100,000. I don't believe I ever said that. The list is attached to the motion. It's around $42,000.
Sustained as to the form of the question, you may rephrase.
Sorry, I misunderstood Mr. Hawley on the hall. $42,000 worth of items. Any pictures taken?
No, that's not what I was there for.
Was there a report taken? Any type of report, any type of statement?
Not that I recall.
So you're just here testifying on what you observed? No pictures, no DNA, nothing, right?
I was there on hired out personally.
No further questions, Your Honor.
Mr. Hawley?
Nothing else.
Thank you, Sergeant. You may step down and you may leave or you may stay as you choose. Call your next witness.
Mr. Claver.